Before we even hear the charges read, understand this. This case is already unusual. We're dealing with a serious felony allegation: assault by strangulation, domestic violence, interference with a crime report, but the biggest question isn't what happened, it's where's the alleged victim. Today's hearing isn't just about guilt or innocence. It's about whether a case can survive when its key witness has seemingly vanished. Stay with us, because what unfolds here shows how fragile, even serious cases can become inside a courtroom.
Also scheduled for today is People versus Sanford Dean Haley. File number is 252198FY. Mr. Haley is here present with his attorney, Rhonda Ives. Also present is Angelique Camfield from the prosecuting attorney's office. Let me actually click into the file. The allegation here is an assault with intent to do great bodily harm by strangulation, with one count of domestic violence and a count of interfering with a crime report. The felony charge is the assault of great bodily harm. That is set for preliminary examination today, and the complaining witness in that case.
Let's pause here, because the charges matter. Assault with intent to do great bodily harm by strangulation is one of the most serious forms of domestic assault. It signals potential lethality. Add multiple domestic violence counts and interference with a crime report, and this is not a minor accusation. Yet, notice the timeline. The alleged incident occurred in June, but charges weren't filed until October, and the arrest didn't happen until November. That gap already raises legal and evidentiary challenges. Time delays like this can dramatically weaken a prosecution, especially in domestic cases where witness cooperation is critical.
Witness in that case is Crystal Lynn Allen. This allegedly occurred on June 16th of 2025. The complaint was filed with the court on October 23rd, 25. The defendant was arrested on November 2nd of 2025. Ms. Ives was appointed to represent the defendant. I saw him on November 3rd and he pled not guilty. Prelim was set for November 25th. Pre-exam was set for November 18th with prelim November 25th. The matter was adjourned. The court found cause to adjourn. I think they were unable to find a witness at that time. Prelim was set for December 16th. Nothing happened. The matter was continued again. And both parties asked for an adjournment on December 16th. And the matter was set for preliminary examination today. My understanding is today and each other day, Ms. Ives, defendant wishes to have a preliminary examination.
That's would be correct, Your Honor.
What you told me on December 16th is you have also been looking for the complaining witness to interview her, and you had an investigator looking for her, and you've been able to unable to locate her. Is that correct?
This is where the case starts to unravel. Both defense and prosecution admit they cannot locate the complaining witness. Daily attempts, investigators involved, working phone numbers, and still no contact. In criminal law, especially at a preliminary examination, the court needs enough evidence to establish probable cause. But when the alleged victim is unreachable, the prosecution's hands become tied. Ask yourself this: can justice move forward when the central voice in the case is completely absent?
That is correct, and my investigator still is making almost daily attempts to try to reach her, find her. We had a working phone number for her that she had answered at one point, but I have not been able to have a conversation with her, nor has my investigator.
Ms. Camfield, what do you know from the people's perspective?
Thank you, Your Honor. The only information that I can provide is somewhat similar to Ms. Ives's. She appeared at my office at the last exam date with a letter purportedly authored. Miss Ives.
Oh, okay.
With her intern, I'm sorry. With a letter purportedly authored by Ms. Allen. I have no idea how it came into her possession. However, I had indicated to her, as I had indicated to the court that day, that unable to verify the author of that letter purporting to be Miss Allen, I cannot make a motion to dismiss or make any offers in a case based upon something that's allegedly written by someone whose identity I cannot verify. I'm concerned about Miss Allen's safety. I do note that purportedly the arrest of the defendant left her homeless when the no contact condition was put into place. And I do know that the sheriff's department, inclusive of Sergeant Penn, have been looking for her. Much like Miss Ives's investigator, they've not been able to locate her, and she has not come physically into the office nor called me. I did call the number listed in the police report in an attempt to make contact with her to explain that I really needed her to come in and identify to me so that we could discuss the matter, and have not received any return calls since that time.
This is
in
a critical
December.
legal moment. The prosecutor admits they could proceed using officer testimony and photos of injuries, but they choose not to. Why? Because of confrontation rights. Under the Constitution, defendants have the right to confront their accuser. Without the victim present, a jury trial becomes dangerously vulnerable to collapse. This isn't about sympathy or belief, it's about what will survive legally. This decision shows restraint, not weakness, and it highlights how courtroom strategy often outweighs raw allegations.
Since that time in December, and again, I called her today and have not received a return call. The people could potentially proceed with Sergeant Penn's statements of the victim regarding injuries that were seen on her person and photographic evidence, but are choosing not to go forward today based upon the fact that even though statutorily it may be enough for a probable cause bind over, it would become more difficult in front of a jury and circuit court to proceed due to confrontation issues. So we are unable to proceed today.
Ms. Ives, are you going to ask the matter be dismissed?
Your Honor, yes, at this time I would make a motion that the matter be dismissed. Obviously, it could be without prejudice. So if this matter became an issue, the prosecutor could seek.
Now the defense
charges.
moves in. A motion to dismiss without prejudice may sound like a win-and in many ways. It is, but it's not permanent. This means the case can come back if the complaining witness resurfaces and wants to proceed. No testimony has been taken, no jeopardy has attached. Legally, this wipes the slate clean for now. But emotionally and reputationally, the impact on both sides can linger long after the gavel drops.
Seek charges again, or if something, if they finally reach the victim and she does wish to go forward, that matter could be reissued. I certainly would advise my client to make himself available if that were to happen. But at this point, we would ask the court for a dismissal so we don't have to keep reappearing, and I could let my investigator off the case.
Mr. Haley, do you understand that a dismissal without prejudice means the case could be rebrought? The dismissal with prejudice means it's done. You can't recharge it. But no jeopardy is attached. No testimony has been taken. You haven't entered a plea. So if the matter is dismissed, it would be without prejudice and could be rebrought. Do you understand?
The judge does something important. Here he ensures a defendant fully understands the consequences. This isn't an acquittal, it's a pause. The case can be refiled at any time if circumstances change. And then comes a striking observation. Despite an alleged violent incident, the parties continued living together for months afterward. That fact doesn't decide guilt, but it complicates the narrative. Courtrooms don't deal in assumptions. They deal in provable facts.
Yes, sir.
Well, this is a strange phenomenon. So this happened in June, and the parties then continued to live together from June to November. And then when he got arrested in November and no contact provision, she got forced out of the house.
That is my understanding, the best I can relay it to the court. And again, this information was provided in the letter whose author is unidentified, at least by verification purposes. It does purport to be Miss Allen, but again, I don't know her handwriting. I don't know her. And I cannot speak with her to verify that she authored that or the circumstances under which it was written.
Your Honor, might I add that the handwritten letter came to me in a photograph through a text message on my phone in my attempts to try to reach with her and schedule an appointment so my investigator could interview her. And that was the document I received. So I can't verify anything other than that is what I received purportedly from her.
I haven't seen it, but I don't need to see it.
Yeah, they were, the parties were living in his mother's home, so I think at that point, when the no contact order issued, she left the residence.
That's always a problem when there's a long delay between the incident and the warrant. There wasn't a big delay between the issuance of the warrants and the arrest, but it was 5
This
months
comment from the
later.
judge cuts to a systemic problem. Delays, especially months-long delays, can derail even strong cases. Memories fade, witnesses disappear, lives change. Add in a no-contact order that leaves someone homeless, and the human cost becomes impossible to ignore. Domestic violence cases are some of the hardest to prosecute, not because they aren't serious, but because they rely so heavily on cooperation from people often caught in impossible situations.
5 months later before he got arrested, and that often causes issues. All right, I've done an order granting the motion to dismiss without prejudice by the defendant. It's
In the
granted for
end,
the reason
this case was dismissed without prejudice, not because the charges lacked seriousness, but because the prosecution could not move forward without the complaining witness. The court followed the law, protected constitutional rights, and left the door open for future action if new evidence emerges. This hearing is a powerful reminder that justice isn't just about accusations, it's about procedure, proof, and participation. If you found this case as complex and unsettling as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more sharp, no-nonsense courtroom breakdowns you won't hear anywhere else.